The presumption of guilt is basically how our country's failure to adequately confront this history of racial injustice that I just touched upon has evolved into a widespread presumption that people of color are suspicious, dangerous, and criminal. People have strong unconscious associations between blackness and criminality, this implicit bias, right? This makes people of color especially vulnerable to wrongful convictions and unfair sentences. Why do prosecutors continue to engage in this conduct? I think one big reason is that there is no accountability. There's no consequence for a prosecutor who violates the constitutional rights of the defendant or the juror.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off today, I wanted to introduce our speaker, Angie Setzer. Angie Setzer is a senior attorney at the Equal Justice Initiative, where she has been representing people on death row and children prosecuted as adults for over 20 years. She coordinates EJI's capital cases, providing expertise and training to lawyers throughout the country handling death penalty cases, and is a leading researcher and writer for reports on criminal legal issues. She joined EJI after graduating from the University of Michigan Law School in 1999. The webinar presentation that you're about to watch will be approximately 1 hour, and you will have the opportunity to ask Angie some additional questions once the presentation is complete, if you would like to. So if any questions come up for you during the presentation, please feel free to submit them through that Q&A button in the control panel at the bottom of your screen. Without further ado, here is Angie to discuss confronting racial bias in the jury selection.
Okay, great. Thank you so much. Well, as Nina said, my name is Angie Setzer, and I'm a senior attorney at the Equal Justice Initiative. Thank you so much for joining me today for this presentation on representative juries and confronting racial bias in jury selection. Before I sort of jump into the substantive part of this, I wanted to give you a little bit of background about EJI and our work in this area. EJI is a nonprofit legal organization located in Montgomery, Alabama, that was founded in 1989 by Brian Stevenson in order to address the crisis of counsel that was facing people who've been sentenced to death in Alabama. So at the time of EJI's founding, about 25% of the people who were being executed in the country were being executed in Alabama, a state that refused to provide legal assistance to people facing execution. Over the last 30 years, EJI has represented hundreds of men and women who've been sentenced to death, kids who've been sentenced to spend the rest of their lives in prison, and other individuals who've been wrongly convicted or sentenced to excessive punishment. Through these cases, we have come to see not only how pervasive racial bias is in the criminal legal system, but really the significance of unrepresented juries on individual outcomes in cases, as well as on the integrity of the system as a whole. And it was through this work and through these sort of what we were uncovering that we decided to sort of do a deep dive into jury selection process in the South, really in about 8 states. So in 2010, we undertook an investigation of sort of what was happening in these criminal cases. We went to courthouses, we interviewed individuals who'd been struck from juries, we pulled jury lists, and our findings were published in a report issued in 2010 that really detailed the ways in which racial bias continues to pervade the criminal legal system. We uncovered communities like Houston County, Alabama, which is in Southeast Alabama, which has an African-American population of about 27%. But at the time, over the course of about 5 years, we determined that the prosecutors were removing about 80% of the qualified African-American prospective jurors from cases in which the death penalty was a possible punishment. These findings, along with our other findings, formed the basis of this report, which was then cited by courts and advocates across the country who recognized how central this issue is. So in 2021, we published an updated version of this report. We really updated not only the research and our findings, but we broadened our approach. So we looked at states across the country, but we also focused a bit more on the early selection earlier stages of the jury selection process and the ways in which jurors of color continue to be excluded at each step of that process. This report, which was made available to each of you today through a PDF and is available on our website at eji.org, really forms the basis of my presentation today. So I'm going to begin by providing some background on the history, our country's long history of racial bias in the criminal legal system, and then specifically with respect to discrimination in jury selection and our country's continuing indifference to this problem. I'm then going to speak a little bit about why representative juries are necessary before moving into a discussion about the ways in which Black jurors and jurors of color continue to be excluded at each step of the jury selection process. Finally, I want to touch a little bit on how our laws have developed to make it very difficult to remedy this problem and our recommendations for eliminating racial bias in jury selection. So before we continue, I just want to present a short introductory video.
Racial bias in jury selection is a serious problem that undermines the integrity of the legal system. Juries are supposed to accurately represent communities and their diversity. But far too often, Black people and people of color are excluded. Even though over 40% of Americans are people of color, more than 95% of all prosecutors are white. Most judges are white as well. Local courts create lists of people eligible for jury duty. But in most cases, those lists underrepresent Black and brown people. When people of color are called for jury service, prosecutors and judges sometimes unfairly exclude them. Then Black and brown people who overcome these barriers can still be excluded by prosecutors who use peremptory strikes illegally based on race. Prosecutors who unlawfully strike Black people from juries don't get fined, sanctioned, or held accountable. The U.S. Supreme Court has said that eliminating racial bias is essential to preserve the public confidence upon which our system of criminal justice depends. That confidence has been shaken. When there is racial bias in the selection of the jury, it's hard to accept the rest of the trial will be fair or that a verdict will be credible. Racial bias in jury selection is illegal. In order to guarantee fair trials for all citizens, states, judges, and prosecutors must eliminate this discriminatory practice for good.
Okay, so I'm just going to jump into the history here after that short introductory video, which kind of is an overview of what we'll be talking about today. As most of you know, the right to a trial by jury is sort of a core tenet of our democracy, right? The idea that you would be tried by neighbors, friends, community members, largely because it prevents the accused from government overreach, from abuse. And unlike prosecutors or judges who are largely appointed or elected, jurors represent ordinary citizens who, represent our values and norms. As our courts have long recognized, and Justice Kavanaugh did in the most recent Flowers v. Mississippi opinion, other than voting, serving on a jury is the most substantial opportunity that most citizens have to participate in the democratic process. But despite how critical and how important it is for juries to protect community members against government overreach, Black people have been excluded from jury service really since America's founding. To justify the mass enslavement of Black people in a country founded on freedom and liberty, an elaborate mythology was created and emerged based on the idea that Black people were inferior and not fully human. And this, in turn, was incorporated into the legal system, which became a critical mechanism for enforcing white supremacy. We see this in our, sort of documents, right? The Constitution denied Black people the right to vote, to serve on juries by characterizing them as property, right? We classify enslaved people as property. Most states denied free Black people the right to serve on juries and a jury trial. And these provisions left African Americans not only unprotected from abusive prosecutions, but also vulnerable to violence and exploitation because perpetrators of violence would not be held accountable. After the Civil War, during this sort of 12-year period that we know that's called Reconstruction, there was significant progress towards racial equality. And in fact, ensuring that African Americans participated in the legal process was a priority. And so we see this, right? We see this in the 14th Amendment, which guaranteed the full rights of citizenship to citizens regardless of race, ratified in 1868. The 15th Amendment, which guaranteed Black men the right to vote, ratified in 1870. And then there was a series of federal laws which authorized individuals to go to federal court for civil rights violations and authorized and empowered the federal government to prosecute civil rights violations as federal crimes. Those are the Enforcement Acts and the Ku Klux Klan Act in the 1870 and 1871. And then I want to mention the Civil Rights Act of 1875, which I'll come back to later in the presentation. This act specifically outlawed race-based discrimination in jury selection. At the same time, during this 12-year period of Reconstruction, white resistance to racial equality grew increasingly violent. More than 2,000 African Americans were victims of racial terror lynchings from 1865 to 1877. And the white perpetrators of these racial terror acts were members of the community. They were law enforcement officials. They were sheriffs. They were community leaders. They were elected officials. And they committed these acts with no fear of prosecution or conviction in an all-white legal system. Amidst this racial terror violence, the Supreme Court sort of began its own assault on the progress that was being made towards racial equality. Prior to 1865, the United States Supreme Court struck down 2 congressional acts as unconstitutional. But between 1865 and 1872, the court struck down 13 congressional acts as unconstitutional. And I want to just highlight a couple of these subsequent Supreme Court opinions. I think these are opinions that we all were familiar with and I remember reading about in law school. The first was the slaughterhouse cases, in which the Supreme Court held that the 14th Amendment's Privileges and Immunities Clause, which was actually specifically written to protect the rights of formerly enslaved people, did not apply to rights derived from a person's state citizenship. And so those rights are only enforceable in state court and not federal court. Of course, state court was a forum dominated by the white ruling class and hostile to claims by African Americans. And then, of course, we have United States v. Cruikshank, which was a case where the United States attorney in Louisiana had actually prosecuted and brought federal criminal charges under the Enforcement Acts against the white perpetrators of the Colfax Massacre. In that case, the United States Supreme Court held that the 14th Amendment provides protection only against actions of the state and not against individual acts of violence, which essentially eviscerated the Enforcement Acts entirely. So towards the end of Reconstruction, we have sort of an end to political progress. And at the same time, it meant that essentially the right to vote and the right to serve on a jury was never fully realized. Although the court upheld the provision on the Civil Rights Act of 1875, which was a prohibition on racially discriminatory jury selection, state and local officials largely ignored this federal law or just found ways around them. And so in the late 1800s, we see examples of this, of the ways in which states are getting around any sort of, federal prohibitions that are left. And one example I want to highlight is Louisiana. So in 1898, the Louisiana legislature amended its constitution with the specific purpose of establishing white supremacy. And so in order to dilute the participation of Black jurors, the legislature passed a law which would allow a felony conviction even without a unanimous verdict, meaning that they only needed 9 out of 12 jurors to convict. So even if you had 1, 2, or 3 Black jurors on the jury who voted to acquit, that was not sufficient, and we could still convict based on 9 out of 12. This practice, again, specifically designed to uphold white supremacy, was not overturned until the 2020 case of Ramos v. Louisiana. Other states were doing the same kinds of things. And so throughout the early 1900s, the United States Supreme Court largely turned a blind eye to what was happening, to the rampant and illegal exclusion of people of color and just sort of deferred to state findings that no discrimination was happening. We see this in cases that came out of Texas, in death penalty cases where, there would be a county that was over 25% African American, and we'd have a Black man sentenced to death by an all-white jury. And the Texas court was simply saying, it's fine. There's no discrimination here based on the state court findings. At the same time that the court is sort of ignoring what's happening, again, the racial terror lynchings and this white resistance to equality was continuing to be more and more violent. EJI has documented that between 1877 to the end of Reconstruction in 1950, more than 4,400 African Americans were killed in racial terror lynchings. So the Supreme Court's lawyers are turning a blind eye. In 1935, they did something, they sort of called out local officials. This was in Norris, Alabama, a case where 9 Black teenagers had been accused and convicted of raping a white woman, despite significant evidence of their innocence. In that case, there was an all-white jury. The testimony established that not a single African American had served on a jury in living memory. And in that case, the United States Supreme Court finally reversed about 6 other cases over the next 12 years under similar circumstances. But the Supreme Court's commitment to racial justice, or eliminating and eradicating racial bias in jury selection, was fleeting. And, states continued to devise ways around any sort of prohibitions. States would come up with putting names on different colored sheets of paper. You'd have Black jurors on one sheet and white jurors on another. The states would rely on segregated tax rolls to form their jury pools. In one case, the United States Supreme Court upheld a Texas county's practice of allowing just one, but no more African Americans on a grand jury. And the Supreme Court said that was fine. So it really wasn't until the 60s and 70s in cases like Swain and Taylor v. Louisiana that the Supreme Court really began to confront and address the exclusion of Black people and people of color from jury service in earnest. Before I sort of jump into all the different ways in which, sort of what's happening in terms of representative juries now, I want to just pause for a minute and talk a little bit about presumption of guilt. So the presumption of guilt is basically how our country's failure to adequately confront this history of racial injustice that I just touched upon has evolved into a widespread presumption that people of color are suspicious, dangerous, and criminal. So, what we just learned is that the legacy of slavery was the myth of racial hierarchy, or the false racial narrative that Black people are inferior, which was created to justify the mass enslavement and really survived the formal abolition of slavery. This myth was reinforced through racial terror lynchings, where white people defended the brutal torture and spectacle murder of Black people as necessary to protect their property and families and way of life. And this myth continues today as a presumption of guilt, which is assigned to people of color, which really targets them for unfair treatment in the criminal justice system. Black men are 6 times more likely to be incarcerated than white men. Latino men are 3 times more likely than white men. Bureau of Justice Statistics in 2003 predicted that 1 in 3 Black young boys and 1 in 6 Black Latino boys would go to jail or prison. And it also has created this sort of implicit bias, which I'm going to talk a little bit more about in just a minute. But numerous studies have demonstrated that as a result of this history and our failure to adequately confront this history, people have strong unconscious associations between Blackness and criminality. This bias has contributed to the mass, incarceration that we see today. U.S. prison populations have skyrocketed from, a few 100,000 people in the early 70s to over 2.2 million people today. So I just want to sort of have that in mind as we move forward and talk about the importance of representative juries. Why do representative juries matter? Well, first, representative juries are often the only opportunity for a community perspective to impact the outcome of an individual case. Second, representative juries engage in a more thoughtful and deliberative fact-finding process and are indispensable to fair and accurate trials. And finally, representative juries instill confidence in the legal system. So let's go back to the first point. Why are representative juries often the only opportunity for a community perspective to impact the outcome of a case? This is largely because even though about 40% of Americans are people of color, judges, prosecutors, and law enforcement are disproportionately white. And you sort of saw some of this in the video, but nationally, about 95% of our nation's elected prosecutors, which are about 2,400, are white. And this isn't a statistic that's confined to states with less diverse populations. In fact, what we've seen, and we document this in our report, is that the disparity is often most glaring in communities with the most diverse populations. So, California, for example, is a state where the population is about 63% non white, but only 10% of its prosecutors are non white. Similarly, Texas, it's a state where about 58% of the state's population is non-white, but only about 13% of the prosecutors are non-white. But it's not just prosecutors. It's judges who are, is overwhelmingly white as well. 20 states currently have all-white state Supreme Courts, including 12 states where people of color make up more than 20% of the population. One example of that is the state we're in, which is Alabama, where all 19 appellate judges are white, even though people of color make up about 35% of the state's population. In 15 states, there has never been a Black state Supreme Court justice. And other groups that have historically been subject to unfair bias and exclusion are also underrepresented. There are no Native American state Supreme Court justices in 47 states, including 3 of the 4 states with the largest Native American population. It's not just state courts either. Federal courts suffer from a similar lack of diversity. You can look at the Fifth Circuit Court of Appeals, where about 75% of the judges on the Fifth Circuit are white, even though more than half of the circuit's population, which is Texas, Mississippi, Louisiana, is non-white. So it's not just judges, it's not just prosecutors, it's also law enforcement, which is disproportionately white. In too many parts of the country, law enforcement agencies don't actually represent the communities in which they serve. We can look at communities in Ohio, Georgia, California, New Jersey, where in some places, the percentage of the white officers is more than 30% higher than the community in which they're employed. The absence of Black representation in these positions means that decisions about who to arrest, which crimes to prosecute, and how to punish people are being made primarily by individuals who have less experience contending with racial bias. Not only are representative juries often the only opportunity to have a community perspective impact the outcome of a case, but representative juries are indispensable to fair and accurate trials. So I mentioned this presumption of guilt and this presumption of guilt earlier, but numerous studies have demonstrated that as a result of this history of racial inequality, people have strong unconscious associations between Blackness and criminality, this implicit bias, right? This makes people of color especially vulnerable to wrongful convictions and unfair sentences. Connected to this, studies have shown that racially representative juries engage in a more thoughtful and deliberative fact-finding process than all white juries. And the point I want to make here is twofold. First, empirical jury studies demonstrate that white jurors are more likely to view Black defendants as cold-hearted, as remorseless, and dangerous. And they also tend to treat Black defendants more punitively than white defendants. Second, studies have also found that representative juries engage in a more thoughtful and deliberative fact-finding process. They consider more factual information. They're more likely to discuss controversial issues like racial profiling. They're better able to assess the accuracy and reliability of cross-racial identifications, which studies have shown have been subject to error. They're more willing to discuss missing evidence and talk about things they wished had been presented at trial. And sentencing disparities tend to decline as juries become more racially representative. Studies have shown that the more white people on a jury, the more harshly a Black defendant will be sentenced, especially if the victim is white. And this is particularly true in cases in which the death penalty is a possible punishment. In a national study involving capital trials in several states, researchers found that in cases with a Black defendant and white victim, all white juries imposed the death penalty 72% of the time, but only 38% of the time when the jury included a Black person on the jury. Finally, my third point is just that representative juries are necessary to instill confidence in the integrity of the legal system. Discriminatory jury selection violates constitutional rights of the jurors, but it's also incredibly humiliating and painful. And we saw this when we talked with jurors who had been removed from jury panels, jurors like Melody Harris, and we talk about some of these jurors in our report. She lived in Lee County, Mississippi for a decade. She had worked at her job for 6 years, and she was called to serve on a jury. She was struck because the prosecutor said she did not have any ties to the community. And I think even at the time, she knew that she was being treated unfairly. Another example is juror Brenda Green, who lived with her husband in Talladega, Alabama. They both worked for a local textile mill. She actually didn't know why she had been removed from the jury until we showed her the transcript of the prosecutor's stated reason for removing her. And what the prosecutor said was that her husband sold drugs and that she was friends with drug dealers. She was shocked because neither of those things was true. In fact, the only contact she remembers ever having with law enforcement was pointing in the direction that a suspect was running when she was being chased by the police in her neighborhood. The Supreme Court has recognized that the very foundation of our system of justice is our citizens' confidence in it. But it's really difficult for people to have confidence in that system if the jury doesn't represent their community. A 2019 survey revealed that 87% of Black adults believe that Black people are treated less fairly than white people by the criminal legal system, and 61% of white adults agreed. So despite the importance of representative juries, most jurisdictions have not adopted readily available and accessible procedures necessary to achieve full representation. As a result, Black people and people of color continue to be excluded at every step of the jury selection process. When the court creates the system, the lists of potential jurors, when potential jurors are notified to come to court, when judges decide which potential jurors are qualified to serve, and when prosecutors use challenges for cause and peremptory strikes to remove the potential jurors. So let's talk about the exclusion of people of color in jury pools, this first step. Okay, the Constitution requires that the juries in an individual case be chosen from a fair cross-section of the community. But Black people and people of color are often underrepresented because the source lists underrepresent people of color. We know that federal courts, pursuant to the Jury Service and Selection Act, federal courts rely primarily on voter registration records as a source for jury lists. Many state courts also use voter registration records as the primary source of jury lists as well. But recent changes to voter registration laws and a variety of socioeconomic, geographic, historical reasons mean that many racial and ethnic groups are not fully represented on voter lists. So if the voter lists are the primary source, it then means that the jury lists are not representative of the community. Some states use driver's license or state ID lists as well. Those lists also tend to disproportionately exclude people of color. And obviously, this is a problem because if the initial master list is not representative, then it's less likely that the final jury will represent the community. After the jury list is compiled, summons go out to individuals who are going to serve on the jury. And this is another point in the process that can create racial disparities. Nationally, about 12% of juror summons are returned as undeliverable. This may be because the court fails to check addresses regularly against a change of address database. It may be because the master jury lists are not regularly updated. Again, this is an area where racial disparities can be created. People with low income levels who are more likely to move frequently have a higher rate of undeliverable summons than middle or high income people. And because Black people and people of color in our country are disproportionately burdened by poverty, they are more likely to be excluded at this point because of this practice. So while these practices have led to significant underrepresentation of people of color in the master jury list, sort of in the initial list, it's very difficult for individuals to succeed in challenging these jury pools as unrepresentative. I'm sure some of you are familiar with what's required to make out a fair cross-section challenge under the Sixth Amendment. The Sixth Amendment fair cross-section entitles a defendant to a trial by an impartial jury that is drawn from sources reflecting a fair cross-section of the community. And there are really three requirements. First is that the underrepresented group is cognizable. Second is that the underrepresentation is significant and not fair or reasonable. And this is where most claims fail, because most courts have used this absolute disparity test for measuring whether the underrepresentation is significant. And absolute disparity test is really just subtraction, right? It's the difference between the percentage of a particular group in the community and the percentage of that group in the jury pool. Typically, courts have required that percentage be greater than 10%. The problem with absolute disparity is that it doesn't actually capture or measure the decreased chance that a defendant will draw a representative jury because it doesn't take into account a group's size. So, as an example, if one group is 75% of the population and 70% of the jury pool, that's an absolute disparity of 5%. Another group could be 10% of the population and 5% of the jury pool, and the absolute disparity, again, is 5%. But the chance that a representative of a group will be impaneled on a jury decline by half in the 10-5 scenario, and only about 7% in the 75% scenario. In 2010, in Borghese v. Smith, the Supreme Court recognized that absolute disparity can be misleading, particularly where a group is a small percentage of the population. And, you can imagine a situation in which there's no legal challenge where that group's population is less than 10%. But states, have continued, or courts have continued to use this test in determining underrepresentation. The third requirement is that the cause of the underrepresentation is a systematic practice. And again, this is a point in which many claims fail, largely because courts are unwilling to find things like source lists or failing to keep addresses up to date as systematic practice. It is true that at this point, there's no requirement of intent. So unlike a 14th Amendment challenge, there's no requirement that the actors are intending to exclude people, but it is still a point at which courts have not really recognized these other factors as systematic practices. So I want to now move on to the sort of next phase of jury selection. After you sort of have the master jury list, after people are summoned to come to court, the jurors arrive and they are qualified. Legal qualifications for service usually include age, that you're a citizen of the county, that you're a resident, that you're proficient in English, and that you don't have criminal convictions. Again, these are points where disparities can occur. For example, English proficiency. Federal courts and most state courts require that you be proficient in English, but 87% of people with limited English proficiency in the United States are people of color. So in jurisdictions with large number of citizens who are not proficient in English, these restrictions produce juries that are actually not representative. Likewise, with criminal convictions, I'm sure many of you are familiar with the fact that being charged with or convicted of a felony can exclude you from jury service in many states. But it's also true that in some states, a misdemeanor conviction can result in lifetime exclusion from jury service. And a couple of states, actually just being charged with a misdemeanor can exclude you from jury service. So these are ways in which additional sort of underrepresentation occurs. Another way that people are sort of removed from the jury at this point is for undue hardship. And this is primarily financial, right? Undue hardships tend to deny people with low incomes the opportunity to serve on juries and further decrease the chance of a representative jury. And we can see this in a couple of ways. Payment, right? All states prohibit employers from retaliating against individuals who are serving on juries. But most states do not compensate individuals for serving on juries. And even in states with generous compensation, for individuals who work multiple jobs or who are self-employed, there is no there's no compensation for lost wages. There's only about one state, and juror pay has not kept up with rising cost of living or inflation. There's actually one state, which is New Mexico, that ties juror compensation to a minimum wage. But again, this is sort of an area where people with, sort of a lower economic income are going to be prohibited from serving. And individuals with childcare needs, individuals who have transportation needs, all of these things limit an individual's ability to serve on a jury and then limit the representativeness of the jury pool by decreasing the individual's ability to participate. Once a juror has been qualified, then individuals can be challenged for cause. That is a cause challenges to a juror who cannot be fair and impartial. But studies have shown that there is a stark racial disparity in the way that challenges for cause are used by prosecutors. A recent study of 12 capital jury trials in Duval County, Florida, from 2010 to 2018, showed that Black jurors and jurors of color were excluded for cause at rates more than twice that of white jurors. In a North Carolina study involving 1,300 trials and 30,000 jurors, it was found that trial judges were 30% more likely to remove prospective jurors of color than white prospective jurors. We see this in studies in Louisiana and Mississippi as well, and those are all documented in our report. And I just want to sort of highlight that in cases where courts have eventually found a Batson violation, that is, the court found that the prosecutor peremptorily removed jurors on the basis of race, there's often a corresponding use of challenges for cause to remove Black jurors and jurors for color. We can look at Flowers v. Mississippi. This was the case I cited to earlier, Justice Kavanaugh's quote. In that case, Mr. Flowers, Curtis Flowers, spent 24 years in prison, and he was tried 6 times in Mississippi. In those 6 trials, the prosecutor removed 41 of 42 qualified Black prospective jurors. And eventually in 2019, the United States Supreme Court found that there was a Batson violation. And so the court's opinion really focuses on the peremptory challenges. But it's important to note that in that case, the prosecutor used challenges for cause to actually remove a significant number of Black jurors. In that case, in the case that was before the court, the final pool of qualified jurors was relatively balanced. It was 88 white jurors and 68 Black jurors. By the end of the cause process, the challenge process, 100 jurors were removed for cause, and there were only 10 Black jurors remaining. So that was 58 Black jurors had been removed for cause. Likewise, in other cases, this has happened in Wells. But challenges for cause are largely unregulated. And as a result, individuals are removed for cause based on things like being victimized by racial bias, experiencing race discrimination, having concerns about the reliability of the criminal legal system. The perspective of African Americans in this country is critical, especially given our history of racial bigotry, and really shouldn't form a credible basis for exclusion. All right, so I talked a little bit about peremptory strikes, but after the jurors had been qualified and remain after challenges for cause, the final step is to narrow down the pool through the use of peremptory strikes. This is a point at which, jurors can be removed for any reason at all. In 1965, in Swain v. Alabama, the United States Supreme Court said that you cannot intentionally remove people based on race. In that case, all 6 Black jurors had been removed. But the Supreme Court also said that it wasn't enough to just show the prosecutor's conduct in an individual trial. You had to show the prosecutor's conduct over the course of several trials. And this burden proved too high for Mr. Swain in that case, and actually for most defendants. So in 1986, in Batson v. Kentucky, the court revisited this issue and allowed an individual to show intentional discrimination in an individual case and established a sort of 3-step legal standard. First, the defendant has to make out a prima facie case, demonstrating that the facts and circumstances raise an inference of discrimination. This is a really low bar, and the court has made that clear. If a prima facie case is met, then the prosecutor is then required to provide a race-neutral explanation for the strike. Again, this is a very, very low bar. The Supreme Court has made very clear that essentially it can be any reason at all. It doesn't have to be plausible. It doesn't have to be probable. It just cannot be race-based on its face. It has to be race-neutral. And after those two steps are met, the third step is that the trial court must then decide whether the defendant has established purposeful discrimination based on the totality of the circumstances. In his Batson concurrence, Supreme Court Justice Thurgood Marshall expressed concern that this three-step process would actually not eliminate racial bias in peremptory strikes. And in the 35 years since Batson, its inadequacy in addressing and eradicating racial bias in jury selection has become fairly apparent. We see that prosecutors continue to use peremptory strikes in a racially discriminatory manner. We see that courts remain largely indifferent to racial bias in jury selection. Defense lawyers are often ill-equipped or unwilling to challenge racial bias. And excluded jurors actually themselves have no remedy for challenging discrimination. So I just want to talk a little bit about each of these things. First, numerous studies document the extent to which prosecutors continue to use peremptory strikes in a racially discriminatory manner. In Mississippi, we have a study of a 25-year period ending in 2017, which found that Black prospective jurors were 4 times more likely to be struck by prosecutors than white jurors. A Louisiana study analyzing 5,000 cases from 2011 to 2017 found that prosecutors struck Black jurors at 175% of the expected rate based on the proportion of the jury pool. And then this more recent study and report out of California showed a study of 700 criminal cases decided by the state appellate courts through 2018 that prosecutors used strikes to remove Black jurors in nearly 72% of cases, while using peremptory strikes to remove white jurors in fewer than 1% of cases. So I just want to spend a little time looking at how prosecutors, judges, and defense lawyers remain largely indifferent to the need for representative juries. So let's start with prosecutors. Prosecutors are elected officials. They're elected from the community they serve, and they're obligated to follow the law. But it often seems that Batson did not deter discrimination so much as incentivize ways around discrimination. After Batson, many prosecutors' offices responded by having trainings, producing cheat sheets for prosecutors, a list of reasons that would have been deemed acceptable by the court. But prosecutors continue to use insulting pretextual reasons intended to conceal racial bias. And we see this in cases all the time. One example is the use of, quote, low intelligence. It's a negative stereotype that has been used throughout our history to exclude African Americans from voting, from jury service, but it's still asserted as a basis for a strike. And we have cases like McGahee v. Allen, which is an 11th Circuit case where the 11th Circuit found a Batson violation, where a prosecutor had asserted that 6 of the 23 African American jurors were of low intelligence, and that was the basis for striking them, even though the prosecutor did not ask a single question and had no information about the jurors' education, grades, IQ scores, degrees, any of that. Another example of this sort of pretextual reason would be living in a high crime area, right? Yeah, or a bad zip code, which is often code for a predominantly Black neighborhood. Or things like, I couldn't form a rapport, or the person wouldn't look me in the eye, or the juror didn't laugh at my jokes. And these are sort of entirely subjective reasons that fail to account for implicit bias of the prosecutor and continue to be used. In fact, prosecutors often put forth reasons that are based on troubling racial stereotypes. This study in California showed that prosecutors rely on racial stereotypes about demeanor to justify strikes in about 40% of the cases. And it's not something that just happened in the past. I mean, we have cases in the 2000s, in the 2010s, 2012, 2015, where prosecutors are using these sort of troubling stereotypes. A New York case, a prosecutor in 2012 said the Black woman was struck because she was too, quote, outspoken. In a Louisiana case, a Black juror was struck because the prosecutor said he, quote, looked like a drug dealer. So these are these are things that continue to be used in criminal legal cases. But why? Why do prosecutors continue to engage in this conduct? I think one big reason is that there is no accountability. There's no consequence for a prosecutor who violates the constitutional rights of the defendant or the juror in removing them based on race. Nothing happens to a prosecutor if she is found to have engaged in discriminatory conduct. There's no disciplinary action. There's no anything. In fact, recent studies have failed to find a single case where a prosecutor was subject to any sort of barred discipline as a result of being found to have violated Batson v. Kentucky. And prosecutors, in fact, regularly get reelected. Doug Evans was the prosecutor in the Curtis Flowers case, and he was reelected to an 8th term after having been found to violate Batson. So in connection with this, I want to just return quickly to the Civil Rights Act of 1875. This act actually survived the Supreme Court's gutting of a lot of the civil rights acts that were passed during Reconstruction. And it's now codified at 28 U.S.C. Section 243, which, the law basically makes it a federal crime to exclude any citizen from a jury on the basis of race. It imposes a fine of $5,000 in 1875, which is the equivalent of about $100,000 today. It was upheld in Ex parte Virginia, this 1879 case, but not a single person has ever been convicted under this statute. And as I'll discuss in a minute, attempts by the excluded jurors to use this statute to hold prosecutors accountable through a 1983 action have actually been fairly unsuccessful. I'm going to get to that just momentarily, but I want to talk first about courts and the courts being largely indifferent to what's going on here. We know that courts are under an affirmative duty to enforce the prohibition against racial discrimination in jury selection. But when we surveyed state appellate courts, opinions across the country, we found that courts are refusing to enforce Batson. We looked at state appellate courts. In our report, we revealed that the highest state court in 32 states, courts that have considered hundreds of illegal discrimination during jury selection claims, not one has found that a prosecutor violated Batson. Example would be a 2014 Mississippi Supreme Court case where the court acknowledged that the prosecutor struck Black jurors at more than twice the rate at which the prosecutor was, at more than twice the rate at which they appeared in the pool, but refused to find discrimination. This is true even where the courts are finding that prosecutors are treating Black and white jurors differently. And in fact, appellate courts in several states have reversed findings of lower courts that a Batson violation occurred. At the same time, many of these state courts are expressing a hypervigilance around policing what we call reverse Batson claims, which is where a defense lawyer is accused of illegally removing white jurors. And I just want to give an example. These are also in our report. Mississippi. So in 95% of the cases in which the Mississippi Supreme Court considered challenges to the removal of Black jurors, the court found no Batson violation to occur. In contrast, since Batson was decided, that same court has reviewed 13 reverse Batson challenges and found a Batson violation in 11 of them. Courts not only sort of are remaining indifferent to the facts and the evidence before them, but they're also creating procedural barriers or procedural bars to prevent even considering claims of racial bias. Some appellate courts refuse to address claims of racially discriminatory jury selection if there's no objection made at trial contemporaneously. Some courts require that multiple objections be made in order to preserve the claim. And so if a state court refuses to review the claim, then of course a federal court is largely prohibited from doing so as well under the Anti-Terrorism and Effective Death Penalty Act, which prescribes the ability of federal courts to review claims that have been sort of barred from review by the state courts. As a result, we've seen individuals who've been executed even though they have significant claims of racial bias during jury selection. And I just want to highlight one of those individuals, Robert Tarver. He's a Black man who was executed by the state of Alabama. He was sentenced to death in Russell County, Alabama, really despite significant evidence that his co-defendant was the one responsible for the shooting. But he was tried in Russell County, Alabama, which at the time was about 40% African American. He was tried by a jury of 11 white people and one Black juror. Later, the assistant DA admitted to removing people on the basis of race, but the state court and the trial court said there was a Batson violation, but that there was no relief because it had not been, defense lawyer didn't properly object at trial. And then, of course, the federal court said, well, we can't review that claim. because it was not properly raised in state court. And Mr. Tarver was eventually executed in the electric chair, actually. So I just want to briefly touch on defense lawyers, because that's sort of the final piece there, right? We have the courts, we have the prosecutors, but we also have defense lawyers who, under the Batson framework, are largely responsible for policing racially biased strikes. But defense lawyers in a majority of the criminal cases are largely underfunded, overworked, without resources or training to effectively raise and prove a claim of discrimination. They're often prevented from access to jury information. Many state and federal, or many state courts certainly do not require that administrators keep jury information. So this is something that defense lawyers actually aren't able to get access to. Some states have laws preventing them from getting access or make it very difficult for them to get access to this information, which would allow them to challenge either the underrepresentation of the pool or other practices that are preventing their client from getting a representative jury. And defense lawyers are mostly white, which makes them less likely to identify and challenge racial bias in the courtroom. At the end of the day, it's not just the criminal legal system has been undermined, the trial is unreliable, but it's also that jurors are being excluded based on race. It violates the jurors' right not to be excluded. And the Supreme Court has recognized that jurors, in fact, may have maybe the most aggrieved, but jurors often have no remedy for challenging race discrimination. Prosecutors have absolute immunity for lawsuits seeking money damages over past actions during trial, including race discrimination. Courts have denied jurors the right to sue to prevent race discrimination in jury selection. And I mentioned this earlier, the Civil Rights Act of 1875. In Alabama and in Mississippi, groups of jurors who lived in the community sued to prevent the prosecutor from intentionally discriminating against them in future cases. In Alabama, the federal court dismissed the case, and the appellate court, the 11th Circuit, found that while it didn't disagree with the facts, there was it accepted the facts as true, that under the abstention doctrine, the federal court could not intervene in state court proceedings. This lawsuit was also filed in the county in which Doug Evans was a prosecutor in Mississippi, and the court there likewise held that the suit was not ripe, basically that the jurors did not have standing to sue because they had failed to show a sufficient threat of constitutional injury. The dissent in that case, I want to note, pointed out that abandoning this type of civil rights suit that historically has allowed excluded jurors to participate in our justice system impairs the jury right itself. So I have about 10 minutes left here, I think, and I just want to spend the rest of my time talking about what needs to happen. Number one, commit to fully representative jury pools to ensure that people of color are fully represented in the source pools from which our juries are selected. We can use multiple source lists, so beyond voter registration lists and driver's ID and state ID lists. States are actually using other kinds of lists, and we can do that as well. Tribal identification lists, tax filing lists, child support lists, public utility records are being used in Nevada. There are lots of ways to increase the source list, which will increase the representativeness of the initial master jury list. Ensure that jurors are summoned actually appear in court. So make sure that people actually get there. There are actually some pretty straightforward and cost-effective ways to do this. Number one, regularly submit names to the USPS change of address database. A recent 2022 report from the National Center for State Courts showed that using change of address database resulted in updating about 10% of the addresses in the jury source list. So that's a really easy way to do something. Also, just renew the source data, update your master jury list. Other options include targeted zip code mailings. So when you get a summons back that's undeliverable, send a replacement summons to that same unit or same zip code. Same thing for weighted summons. Here's a way that you can use geography as a proxy for race or ethnicity. Divide the jury area into smaller units or geographic groups, and then require proportional representation from each of those units. There are lots of sort of straightforward ways to make sure that initial jury pool is representative. Okay, so what else can we do? Remove procedural barriers to review of claims of racial bias in jury selection. I touched upon this earlier, but in state court, the general rule is that there has to be a contemporaneous objection in order for an appellate court to review a claim of racial bias during jury selection. Some states actually permit appellate courts to review Batson claims even if not preserved at trial. And some states review Batson claims even if they're raised for the first time in post-conviction litigation. Federal and state courts can and should be required to remove barriers so that they are able to review on the merits any claim of illegal discrimination during jury selection, even if the claim was not properly preserved below. All right, third, create accountability for decision makers who engage in racially discriminatory jury selection. So, like I said, even when a court has found that a prosecutor has engaged in discriminatory jury selection, the prosecutor rarely suffers any consequence. States and Congress could create a private right of action for legally excluded jurors. Federal courts have really created these procedural barriers, which protects prosecutors from federal lawsuits and shields them from financial liability. But Congress can and should consider reassessing the doctrines of immunity for state officials and remove procedural barriers by federal courts. Okay, peremptory strikes. So reforming the use of peremptory strikes. Echoing Justice Marshall's concern that the Batson three-step process would not eliminate what's going on in terms of racial bias during jury selection, Arizona actually in 2021 eliminated the use entirely of peremptory strikes in civil and criminal trials. But other states are, sort of doing similar things. California, Washington, Connecticut, New Jersey. Washington actually adopted this rule in 2018, which designates a list of presumptively invalid reasons given by a prosecutor. And those are reasons that have historically been used as pretext for removing people based on race. So these reasons, law enforcement or living in a high crime neighborhood, all of these are presumptively invalid reasons. Connecticut and New Jersey have used a similar list of presumptively invalid reasons. They also have eliminated Batson's first step and the requirement that the proponent prove intentional discrimination. And instead, in Connecticut and New Jersey, they are using more of an objective observer standard or a reasonable, fully informed person standard, meaning that if that person were to believe that based on the information available that the prosecutor engaged in discriminatory conduct, then the Batson challenge would be granted or the strike would be denied. California has done something similar where they've, created this list of presumptively invalid reasons. Other states have done, have engaged in similar sort of reforms, have established judicial conferences to look at this and are really trying to figure out how to eliminate racial bias in jury selection. Next. So when faced with clear evidence of racial bias, courts should adopt a meaningful presumption of discrimination and the practice of using absolute disparity so that you can actually use an analysis that accurately reflects the harm that is done to a defendant's chance of drawing a representative jury. Judges should be required to intervene, even in the absence of an objection. And in some situations, the prosecutor's history of discriminatory conduct should trigger more scrutiny by trial and appellate courts. Other state and federal courts have commissioned studies on proposed reforms, and other states are doing other things. So California in 2020 adopted the Racial Justice Act, which makes it illegal for any state actor to obtain a conviction or sentence on the basis of race, which includes racially discriminatory jury selection or racially discriminatory language. So there are lots of ways we can sort of address this issue. And other jurisdictions are considering and implementing other reforms to the jury selection process. I would encourage you to visit our website at eji.org for updates and ongoing developments in the criminal legal system. And I appreciate your time today. Thank you for tuning in to this presentation on confronting racial bias in the jury selection system.
Wonderful. Thank you so much, Angie. And I think we have a few moments just to take a couple of questions. So if anyone has any, please feel free to submit them through that Q&A button in the control panel at the bottom of your screen. It looks like we already have a couple, so we can go through those and then we'll wrap up for today. Okay. Our first question is how do you envision the implementation of EJI's recommendation at both the state and federal levels, considering potential resistance or challenges?
Yeah, I mean, I think this is obviously a challenge. I think there are actually ways that courts, so there's sort of individual cases that we can work on, but there are ways that, and I think there's a range of different things that can be done, right? We have broad strokes like the Racial Justice Act. We have on a more sort of individual level or state court level, individual states that are really taking a look at this. I mean, New Jersey, Connecticut, all of these states, even the Colorado Supreme Court, they recently granted cert on an issue like this. So I think that there are ways that courts are evaluating the process, and we can, as advocates, become involved in responding to proposed court changes, proposed rule changes, really sort of like monitoring what's happening and getting involved in these individual cases. And I think also education. I mean, frankly, this was one of the reasons we did that, is making sure that people understand what's happening. I think people commonly understand jury service to be kind of a pain, often for the reasons we identified, because it's a financial hardship. It is a pain, but how important it is to make sure people understand like that is a critical part of our criminal legal system, and that we want to make sure people are educated around that as well, which is part of the reason we're doing this.
Awesome. Thank you for that insight, Angie. And building off of something similar, this question is how can legal practitioners actively contribute to creating that accountability in the jury selection process?
Yeah, I mean, I think that is like in a number of different ways. Both if you're sort of a trial practitioner, obviously it's sort of there's more obvious ways, I think, but happening in your jurisdiction. I mean, finding out, does your jurisdiction, how do jury summons go out? How, what is the process for tracking demographic information? I mean, this California whitewashing the jury box, which is the report I referenced earlier, really documented the way that people are being excluded. But they came out with a new report, which actually really looks at how states are not actually collecting demographic information from jurors. So things like, getting questionnaires, making sure that in individual cases or in individual jurisdictions, we are actually getting this information so that we have it and we can then make challenges. Sorry, I know that's a very quick answer. There's lots of questions and I only have like a minute, but
No, that's okay. I think we'll just take one more question.
that's one, sort of on that.
Yeah, it's okay. This person asks, how effective have challenges been on the absolute pool issues? Say one area is 3.8% African American versus 87% white.
Yeah, I mean, I think the when we did our report, we found that in the last 10 years, only one case had succeeded in challenging the so the underrepresentation in the jury, the Sixth Amendment Fair Cross Section challenge. I know that there are states that are actually getting rid of the absolute disparity test. States like Iowa, where they've adopted a new test. So there are jurisdictions, and I think particularly in light of Borghese v. Smith, where the U.S. Supreme Court sort of acknowledged this test isn't going to work, specifically in areas where you have populations that are really under 10%. You can imagine that there's really no legal challenge. And so states like Iowa, I think there are other states that are considering reforms. I don't actually have an update. I don't know how many successful cases there have been since then. I know that in the past there haven't been that many, but I think sort of moving forward, looking at ways to get rid of this test and informing courts about the problems with these various comparisons can be a huge first step.
Awesome. Well, I think that will be our last question for today. Thank you so much for your insight, Angie, and thank you all for your questions. We want to thank you for joining us today for another Justia webinar. Again, as I mentioned at the top of today's presentation, as you're all members of Justia Connect, I wanted to remind you all of the benefits you can gain access to by upgrading to Justia Connect Pro. When you upgrade, you get access to those benefits like getting CLE credit for presentations like today. You can also get CLE credit for watching on demand. You'll also get that pro badge featured on your Justia Lawyer Directory profile and the ability to feature reviews on your profile. as well as that $200 credit to help you save on select Justia marketing solutions. So if you'd like to find out more about that, feel free to go to pro.justia.com. Thank you again for joining. Thank you, Angie, for your time, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.